listening to this show. He's he's the man we usually tend to on all matters of law.
So I am a learned or a colleague or a learned.
He's my lawyer.
And he acknowledges it every time.
Oh,
He's my lawyer.
There you are. Good morning.
Good morning, sir.
I hope you're well.
I'm very well.
Yes. And it's nice to have you on the line. I don't know if you've had the opportunity of listening to Honorable Alexander Afenyo Markin'S. A couple of points he makes. He believes that there's no basis.
I had a bit of some voice clips on what he said, but I won't say I listened fully or read fully what he's led to have said.
He is suggesting a few things. One, on the application of the law in question, I think Section 2071 of Act 29, Section 208 of Act 29. He says that if you listen to what Afenyo Markin'S said, one, he feels that that law should not apply in the manner in which it should be applied. It should be a civil matter that the judge in question should have essentially taken him to court. Maybe for defamation or whatever it is, that it should not be a criminal matter. Secondly, he says that even if it becomes a criminal matter, the manner in which the bail issue was handled was not in accordance with law, because you cannot hold somebody on the presumption that if you grant the person bail, the person will go back and do the same thing over again. I think those are the major points that he's held. He's going into the politics of the NDC, then bringing back the criminal libel law, among others. What do you think?
Wow. First of all, Honorable Afenyo Markin'S, let me call him Alex, is a lawyer and he's a lawmaker as well. He's a member of parliament and has held several leadership positions. He's also been a politician for that matter and has held high profile public offices. And so, if it is the case of Alex that the substantive legal provisions of Act 29, under which the accused person, Abronye, has been charged and placed before court, is no longer good law, or that it is repressive, because listening to him, he made some references to the historical antecedents, such as the criminal libel law, and how eventually his party initiated steps to have the same repealed. I believe that as a lawmaker and a lawyer, Alex would have led such a move once more to have this provision, section 207 of Act 29, repealed in the same manner as the criminal libel law was repealed. So I don't seem to understand him as saying that that provision is one, amenable to manipulation and misuse by the state? Or is he simply saying that that law is bad and offends provisions of the Constitution, in which case he could have proceeded, for instance, to the Supreme Court to seek a declaration to that effect? Or do I also understand him as saying that the particular conduct complained of by the state against Abronye will not constitute an offense properly so called under the provision of this section 207? If that is the case, where the fact of the case or the conduct does not constitute an offense correctly placed under a provision, such a charge will be bad in law. And I believe as a lawyer, and I don't know whether he's a member of Abronye's legal team, we ought to know exactly what to do when an offense is charged under a provision and the facts do not support such an offense or charge. It applies to the court to have the charges struck out or something as being bad in law. Also, it seems to me that his whole problem centered around the denial of bail.
Yes.
So there's so much confusion as to what exactly his complaints are. If his main concern has to do with the denial of bail and he finds the same to be unjustified, I believe I have been a criminal defense lawyer. I've never been a prosecutor because I don't work at Attorney General's department. So I can only be in the same position as Honorable Afenyo Markin'S and the legal team of Abronye. That as a criminal defense lawyer, we always or most often face this kind of frustration when you expect that your client will be granted bail, even at the police station, at the investigative stage, and is denied, or in court where bail is denied, or bail granted, but the conditions of bail are set to be so onerous as to amount to a denial of bail. The proper approach, especially by a lawyer of that standing, should not be this kind of ranting in the media. Is quite appalling. I am underlined that so shocked to hear the kind of words, the invectives, the innuendos, and all the insinuations and finger pointing. I find that to be so bad. A conduct that should not be encouraged from senior members of the bar, particularly public figures of this standing. Such statements should be coming from maybe ordinary lay persons who may not understand the mechanics of courtroom practice. Is Alex saying that because the offensive charge are essentially misdemeanor, then an accused person is entitled to an automatic grant of bail? I think not. Even in very heinous crimes, bail is ordinarily granted. But the court exercise very wide discretion in these matters, and this discretion has not been taken away. We all agree that under the section 96 of the criminal and other offenses and related, that is the criminal procedure code, as it used to be called, at 30. The discretion given to a court or a judge hearing a criminal matter to grant bail has not been taken away. And so where a judge is found to have abused that discretion or exercised that discretion wrongfully or in a non-judicial manner, the remedies are available and well known to all practitioners.
But he said in this case, they are yet to cite an order. As at the time you were speaking Sunday, that there's no official order. They've looked for it. Can you make an application to the High Court without seeing that order?
The fact that you were seated in the courtroom and heard the judge make an order, who says that the police have to wait? He's suggesting that the order or the remand order or remand warrant, that is called, he could not get a copy of it, and therefore the law enforcement, that is the police, have no authority to effect the remand order. The order has been made, and I believe that every order made in court is first entered into the record book in front of the judge. And if there is electronic recording, it's also recorded. But it takes quite some time for the order to be typed and drawn up, given to the judge to read through and make corrections. And then the registrar, after the judge has signed the corrected version, the registrar now makes certified copies, which ordinarily we as litigants apply for. So it is not unusual that 4 days after that order was made, a copy is not available. I'm not trying to justify any such delay that are commonplace in the court registries. But we all know that such things do happen. And I don't think that the police or the DNI officials will have to wait for the order to be certified and issued out to them. Once the order was made in open court and entered in the record book, it remains an order. And to your question, whether without a copy of the order, an application for bail could be formally lodged at the High Court, the answer is yes. Because on affidavit, evidence that Abronye was brought to court on that day at the Circuit Court, and that an application was made for bail by his lawyers, but the same was refused, and that as of the date of the repeat application before the High Court, the accused person remains in custody is sufficient. This deposition without a copy of the order will be sufficient, because I don't think that the state or the republic, the East lawyers, will be able to deny this express deposition and affidavit simply because a copy of the order has not been attached.
Interesting. Because there are lots of things he says there. And I know you heard him talk about question even if the judge went to law school, among others.
And you know what? I'm still in front of the court, the very big court as I'm talking right now.
The Adenta Court.
Oh, I said the big court, the biggest court.
Okay, the Supreme Court.
Yes, so I'm being careful. I don't know whether I'll also go overboard and I've been lumped together with him. But I found the statements made by Alex quite unfortunate. So, mind you, this offense for which Abronye has been arraigned before court has to do with matters that were deemed to have been an attack on a sitting judge. Is that not the case?
Yes.
And if I were Abronye or his legal team member, I should be worried, because the conduct of Alex hasn't helped matters at all.
Really?
Not at all. I should be worried. If I were to be Abronye's lawyer, I will immediately call him to order. He is not helping Abronye at all.
But I guess he was thinking about if political pressure is brought to bear on the judge.
Political pressure on a judge. A judge who is seized with a matter. And you think that the best way as a lawyer to exert pressure is political and not through the judicial process. There are so many avenues to seek redress. This bill that was refused, I understand the matter has been he has been remanded to reappear in 2 weeks or something. That is long enough a period. With reasonable diligence, I expected them to have filed a bail application by now. They may have even had a date for hearing this week at the High Court. The decision of the Circuit Court is subject to a review or what do you call it? To be revisited by the High Court. By now, I expected them to be at the High Court in a formal and fresh application for bail, instead of holding press conferences and no, it's just, in fact, what Alex is heard to have said is worse than what has landed Abronye in custody right now. What Alex has said is worse. In fact, 10 times worse.
Really?
And that is why I'm saying that it beats my imagination how far he went to town with this matter, simply by saying that, in fact, what Abronye said was nothing, and that given the opportunity, he will say more. Or if it were to be him, Alex, he will do more. That's what he has done. If it were to be some other offense, having nothing to do with scandalizing a court or attack on a judge, that Alex has gone to town this way, then we will be discussing him rather than what occasioned his statement.
Okay.
So I thought that he would have been guided more with what actually brought about the offenses and the charges fed against Abronye that has landed him in trouble with the law. Moderation, I think, is what a criminal defense lawyer must exercise in circumstances like this. Sounding apologetic, trying to show some level of remorse, and doing acts that show clearly or set a signal to the bench that, given the opportunity, his client, I believe his client or his colleague Abronye, wouldn't have to repeat that conduct. But a lawyer and a lawmaker who is concerned about a client or a colleague in custody goes to town to that extent. I think that he hasn't helped Abronye at all.
Well, he said he's not afraid of being dragged before the court for contempt.
It is not about he being bold and fearless that we are talking about. I mean, I don't think that he is the most courageous when it comes to advocacy in court or going in and out of the courtroom. He will be surprised. I've sat in the courtroom in the Supreme Court in 2013 during those the election petition trial, and those who made scandalous statements and were brought there. I was there where the late Sir John appeared. I sat there. I was there. Is it Olsen Adoe?
Yes.
Was brought. I was there. And is it Crunchy?
Yes, Ken Crunchy.
Ken Crunchy.
Yes.
I saw all of them.
I think at some point Samuel Oku too.
Samuel, they were visibly shaking like babies. Look, one drop of the gavel by a judge will change your circumstances, if not forever, just for a moment. Look, nobody can take a court for granted. The power of the state behind a judge, even the smallest at the lowest tribunal. So he says he's not afraid. Nobody says he's afraid. It is not about being afraid or being fearless. It's about a conduct that is dignifying. That's all. Dignifying of a profession, of a lawyer, a lawmaker, and a public figure like him, unlike me, my ordinary self. You see, there is that difference between courageous, and being foolhardy. I think this is not courage, but foolhardy.
Thank you. Thank you very much for speaking to us.
You're welcome.
Well, so that's lawyer David Ametefe joining us on the line, asking a few questions of the minority leader about the application of the particular law in question and about the conduct of the judge as it happens in practice. Sometimes, what can I say? Me, I'm not the lawyer. I've seen something, but I am not a lawyer. But what I've seen sometimes, when people are talking, I get a little confused. Anyway, let's speak to lawyer Sam Atikwe, who is General Secretary, Ghana Law Society. They took a sort of a break. In fact, they provided an alternative to those who seek to perhaps walk out on the GBA, the Ghana Bar Association, for a failure to stand up for justice on every occasion, not on some occasions when some particular people are involved. Thank you very much for your time and good morning to you.
Yes, good morning, sir.
I hope you're well.